Time being 6 o'clock, August 16th. I'll open the Tilton ZBA meeting at this time. And we're here this evening to basically just cover one issue. But before we get started tonight, I'd like to apologize for the confusion in the notice of decision. The board's decision and the intent was to suspend the original decision for further consideration with the intent of starting the deliberation phase of the case over again so that there can be a new deliberation, a new motion, and a new decision. Somehow, in the notice of decision, the word rehearing crept into the notice, and it should not have. And so there might be some misunderstanding there. So with that, being said, I'd like to start the deliberation on case 1601, which is a request for a variance asking to be allowed to do auto repair within the mixed-use district in the Lockyer section of town. Has everyone got a copy of the minutes? They've been able to read the minutes that were approved at the last meeting? And everybody done some homework relative to it, so you're familiar with the situation? Well, I was going to suggest that we read the minutes of that last meeting. Everybody had that. And okay, you ready? I'm going to read the minutes. Stand by. Okay, the case starts out with Mr. Perkins explained his request, indicating that he would not place anything in front of the property other than a sign. He said that other than the sign, nothing would be seen from the road, adding that this would keep the use from being a hindrance or eyesore to those passing by. Mr. Perkins also said that he has improved the appearance of the property and that he would continue to do so, provided he is granted permission to remain at the location. Mr. Brown asked how waste fluids will be handled. Mr. Perkins said that waste oil is kept in a tank in the building, and that waste coolant is picked up by an outside recycling and recovery contractor. Mrs. Yo asked about the hours of operation. Mr. Perkins said the normal hours would be 8 to 5. But that he also conducts 24-hour emergency repairs. Chairman Bussner asked if there's any room in the building for additional businesses, at which time Mr. Burke, who is the owner of the property, said the remainder of the building is currently being used to store Class C vehicles. And Mr. Perkins said that if the individual storing cars were to move out, he would want to occupy that additional space. And then Chairman Bussner said that two primary issues were surfacing. The first, he said, was that the proposal involved a change of use and the site plan review would seemingly be necessary. The second, he continued, was that the board would need to find an existing hardship in order to approve this request. And Chairman Bussner invited the board to consider whether hardship would be in place. Now then, the amendment that was later approved, so far I've read to you the draft set of minutes, and then of course the amendment was then added to really cover what took place. And it's at that point in the minutes, that one little paragraph there where Mr. Perkins read his written responses to each of the 5 various criteria presented in his application. I provided a correction stating the property is not in a commercial industrial zone. That is limited, that paragraph. The new wording that took place from that point on in the approved set of minutes Mr. Perkin read his responses to each of the 5 criteria as presented in his application. In response to Mr. Perkins' statement regarding the second criteria, spirit of the ordinance, Chairman Plessner asked Mr. Perkins to clarify his written statement that he was going to finish cleaning up the place and landscape it nicely. Mr. Perkins said that he owns an excavation landscaping business and will put some flowers in front of the building and make it presentable. And I asked Mr. Burke if he was aware of this proposed landscaping. And Mr. Burke said that the entrance to the building is now basically raw dirt and that any landscaping would be an improvement. Adding that the area from the road to the front of the building would be the maintenance responsibility of Mr. Perkins. And Chairman Plessner asked who would be responsible for removing the items from the building, and Mr. Burke said that he would be responsible for the items, describing them as a pole building and a portable schoolhouse, adding that he expected that the town might want him to do something with them. Chairman Plessner said that the matter could be addressed during the site plan review. Mr. Brown asked what he might do with the items. Mr. Burke said that if he knew he were going to be collecting the rent on a regular basis, he could likely spend the money to take them apart and remove them. Mr. Burke said that he hoped to pave or regrade the parking lot, and that all the water from Route 3 pitches into the driveway and comes down the front of the building. Mr. Burke said that he thinks the state is going to conduct major work in that area involving the installation of a flashing light and the removal of the hill in front of Silver Lake Road to alleviate a traffic safety hazard. And Mr. Burke stated that the state once told him that the sign was in the right-of-way and required him to move it. However, the state later told him that the original location actually was not in the right-of-way. Mr. Burke said that it has all worked out fine. He said the police would verify the fact that they have never had an issue with people coming through that driveway. Mr. Burke said that a motorhome, was once driving up the road the other way and it crashed in a telephone pole or the wall, and that the incident had nothing to do with the ingress or egress of from the property being discussed. In response to Mr. Perkins' statement regarding the 4th criteria, the value of surrounding properties, Chairman Plessner asked Mr. Perkins if he actually believed the proposed improvements to the site would serve to increase surrounding property values, noting that Mr. Perkins would not be making significant changes to the building. Mr. Perkins said that it would become a nice-looking building instead of a crappy-looking building, drawing the analogy of someone showing up at the zoning board meeting in a tank top versus someone showing up in a nice collared shirt, adding that he was wearing the T-shirt that happened to be in his truck. I don't know what that had to do with anything. Chairman Plessner expressed skepticism that the level improvements being proposed would actually serve to elevate the surrounding property values. In response, Mr. Perkins' statement regarding the 5th criteria on unnecessary hardship, Chairman Plessner provided correction, stating the property is not in the commercial industrial zone. Chairman Plessner asked that board to consider how it would rule if Mr. Burke, the property owner, who was seeking the variance, adding that there would be absolutely no hardship of any type in that instance. And Mr. Helwig said the hardship would be the circumstance of having an empty building that one cannot use when there is a similar use being exercised elsewhere in the area. Mr. Sassan said the hardship should be specific to the particular property. Says that any alleged hardship stemming solely from the restrictions imposed by the chart of permitted uses would not sufficiently satisfy the hardship criteria for granting the variance. Mr. Helwig said that the building has not had a successful business in it since it was a hardware store. He said that allowing the proposed use might make the property more successful because it is a common use for the area and people would expect to find such a business in that location. He said that other types of businesses have failed there. And Mr. Sasan granted the following from the New Hampshire Office of Energy Planning Board of Adjustments Handbook. Restrictions on one parcel are balanced by similar restrictions on other parcels in the same zone. When the hardship so imposed is shared equally by all property owners, no grounds for a variance exists. Only when some characteristic of a particular land in question makes it different from others can unnecessary hardship be complained. And Ms. Yo said that the building sits down and away from the road, which makes it difficult to see from the road. She suggested that this might represent a hardship. Chairman Plesser said the building's location on the site would not preclude a use such as a landscaping business. Chairman Plesser expressed concern that if the board would grant this request, it would be open to the possibility that the business might expand in the future. The board discussed a possible condition of approval which would limit the number of cars on the building's exterior to 6, excluding employees. Chairman Plesser asked if anyone from the public wished to comment, and no public comment was provided at that time. Chairman Plesser said that there should be a condition requiring site plan review approval be obtained, and Mr. Sasan suggested that it should, as such a condition, be worded more generally to direct applicants to the planning board, rather than to specifically require a site plan approval. Mr. Brown said that it is not the responsibility of the zoning board to determine whether site plan review is required. And Mr. Sasan agreed, adding that there exists a change of use form which refines criteria for determining whether site plan review is necessary, and that the land use department of the planning board should use that form to determine whether site plan review would be necessary. Chairman Plesser proposed the board to determine that abandonment shall have occurred if the automotive repair business ceases operation for a period of 12 months or more. At that time, Mr. Sasan said that courts have established a precedent for what constitutes abandonment, and that it might therefore be inappropriate for the board to assign an ad hoc definition in this case. Chairman Plesser questioned Mr. Sasan's suggestion that the zoning board should not establish a case-specific abandonment criteria, and said that the potential validity would be debated by the courts if the decision were ever questioned. At that time, Chairman Plesser and board members they all agreed that there exists a hardship due to the type and location of the building, and the board members expressed agreement. At that time, moved by Mr. Brown to approve the ZBA case granting a variance pursuant to Article 6(1)(g)(3) to allow for motor vehicle repairs and maintenance at 496 Laconia Road with the following conditions. Maximum 6 vehicles shall be present on the exterior premises, including employee vehicles. The planning board shall be consulted to determine whether site plan review shall be necessary. And 3, that this approval shall become null and void if the automotive repair aspect of the business is ever abandoned for a period greater than 12 months. This was seconded by Mrs. Yo. All in favor? None opposed? Motion was approved. And that was the end of that case. So now that we've gone over all of that, and everybody's got a feel for what took place at the meeting, I've just opened it up right now to general conversation with the board. Talk to me.
Well, do we want to go over it criteria by criteria again to make sure?
Well, we're going to do that next. We're going to do this specifically for each one. But based upon the minutes, obviously there were some things in those minutes that were totally unrelated to the case and just gobbledygook as far as I'm concerned. But they were said, but they really didn't mean anything. It did certainly show without evidence that, contrary to accusations, we did talk at length about the criteria. Obviously, in the original draft set of minutes, that wasn't covered. But we now know that there was quite a bit more that was discussed.
Going back over everything. thing, had a second look at the criteria that we discussed. And essentially, just wrote down my thoughts at the time, how they relate to each one.
You know, that seems to sound more like you're addressing this towards the criteria itself, is it not?
But I still feel comfortable with the decision that we made that night.
I do also.
Okay, well, considering that everybody's content right now, that going over the minutes has refreshed everybody's memory as to what took place at the meeting. We can go into the criteria itself, and we'll cover them all again individually. And as you've noticed, I've laid before you something from the procedural basics planning and zoning board, that was the links to all lectures. I'll give everybody a copy.
I think yours got one. You have an extra one there on the table?
Oh, share mine with you.
No, it's not a big deal.
Huh? No, it's okay, we're good.
I don't need
I haven't
one.
got mine highlighted.
Get
This
yours.
guy's glasses on so we can share.
Long ranges.
The way the law lecture book covers it, the first thing it does is the public interest in the spirit of the ordinance. It says that the two elements are related. And for a variance to be contrary to the public interest and inconsistent with the spirit of the ordinance, its grant must violate the ordinance's basic zoning objectives. And there are two methods to answer this question. One being to examine whether granting the variance would alter the essential character of the neighborhood. Okay, that one statement being said, how do people feel about that?
I think with the other uses in the area would not alter the area except for the good by taking the derelict building and turning it into something useful.
Yeah, my thoughts exactly. If anything, I'd be an improvement.
Yeah, and it's, and looking at the property itself, what's different about that property from any of the other ones is the elevation related to Route 3 is much lower. The building is much further out of, I don't want to say it's out of sight, it's not out of sight.
Yeah, totally, no.
But it has a disadvantage that the buildings and the other businesses on the strip are all level with the road. This is below the level of the road, which in any instance would make it less seeable or less appropriate for, say, a retail business or something like that.
Oh, yes. Looking at the terms essential character of the neighborhood, in any way, is it going to alter that?
No.
Nothing's going to change. The building is
That's correct.
going to be there. It's still going to be there.
Right, yeah.
It's just going to be used for something.
Right.
So, I mean,
Yeah.
that-
And the use doesn't.
that part of the decision is going to be simple.
The use doesn't change the area either.
Well, true, but we'll get into that element of it here in a moment. Ladies, you have anything you want to put in there?
It's not gonna change anything, it's gonna, the business is exactly the same,
Okay.
across the street from it.
And they're successful.
That's-
That illustrates an interest in demand.
The minute showed that Mrs. Young also made that statement relative to that. The second part of that is to examine whether granting the variance would threaten public health, safety, or welfare. Talk to me.
I didn't find it that way. I actually went back and looked at the purpose of the zoning district. Is this less would that the purpose of our zoning is to lessen congestion in the street. This would not violate that. To secure safety from fire, panic, or other danger, it does not violate that. The property is adequate, provide adequate light and air. The property does not change that in any way. Prevent the overcrowding of land. There's no change to the land. Aside from that, by right, it could be a public parking lot. So you could certainly have a lot of cars down around there without being an issue. To avoid undue concentration of population, is not going to increase the population because it is not a residential unit. And facilitate adequate provision of transportation, water, sewage, schools, and other public requirements. It does not violate that. So it in no way encroaches on our
No,
purposes.
it doesn't affect Article 1.1 at all.
And like you say, the zoning one itself states that it's good for small retail and public service
And this is
business.
a service business, right?
So it's already an area that's for business uses.
May I just ask a question make sure I have the minutes right? Are you covering public interest right now or spirit of the ordinance?
Well,
We're covering public interest and spirit of the
Okay.
ordinance.
All right, thank
And according to the law lectures, the two elements are directly related. Anything you want from me?
actually, you guys covered, George thoroughly covered everything I had to. My thoughts on it were exactly the same. As far as the purpose of the ordinance, the spirit. Definitely there's an interest there, demand for that type of business demonstrated. So, no, I have nothing else to add to those at all myself.
Mhm.
What's the unnecessary hardship?
Everybody's comfortable with that statement and the way it's been covered? Whether you agree or not is immaterial, it's just that will be determined by your vote, which we're not doing at this point in time. So then we come to substantial justice. Any loss to the individual which is not outweighed by a gain to the general public is an injustice. The court will also examine whether the proposed development is consistent with the area's present use. And that being said, if the individual can't carry that kind of a business, but nobody else is gaining anything by him not being there, or by him being there, it's a non-consequential thing, that he's going to be there, and it's not gonna hurt anything one way or the other, gain or loss to anybody.
Correct.
If anything, it makes the property usable.
It's a gain to the
Yeah, let's use it for something.
Right.
Obviously, it's been empty for the last couple of years. It's had failed businesses for the last 10 years.
That's correct. And the business that was successful there wouldn't possibly do it because it was driven out by Home Depot.
Competition, yes.
So the competition in the area would not allow that to be a hardware store again.
Right.
You know, so the likelihood of that building being used for any kind of retail is, I think it's very limited. Possibly, I don't think there's a chance of that.
I think it's fair to say that all of us are very familiar with the site
Yeah.
and the buildings and everything that are there. And if he can't use it for anything else, why shouldn't he be allowed to use something? The town has no problem charging him taxes on it, whether there's anybody there or not.
Yeah, you got, so basically, you've got substantial justice getting done for both parties. The applicant and the municipality.
Yeah.
Requesting the revitalization of a vacant interior middle.
So we all comfortable with that criteria being covered?
Oh, yeah, yeah.
Okay, I'm gonna jump to the next one, to hit the last one, the property value. And then we'll hit the hardship one next. The property value evidence of effect on property value would be provided only through the offer of proof of an attorney representing the applicant. The court found this evidence was sufficient to form the basis of a decision, since the ZBA found the representation to be credible and consistent with his own knowledge and experience and observations. And that, of course, is relative to a particular case, Continental Paving versus Litchfield. But the fact that the building is not going to change, and if anything, the site might be cleaned up a little bit. So it's certainly not going to hurt the property values that are there, considering some of the stuff that's around already, which is nothing to brag about, but it's pleasant.
We have testimony that potential pollutants will be properly disposed of. It won't be leaching into the ground.
Right.
I agree with you 100%. The improvements in the structure and the grounds would make a big difference. The value of the surrounding property.
To increase the turnover of the air.
You would think at some point, hopefully it would.
Yes.
I mean,
Well,
everything
it's certainly
considered,
not gonna do anything if the building stays the way it is and gets worse.
it's just gonna get worse and eventually become dilapidated and then really a negative to the whole thing. So if somebody fixes it up somewhat, not that they make it look like brand new, but if they can clean it up and do stuff worthwhile with it, which there is a possibility that will be done, then it will at least keep the property values in the immediate vicinity on balance with what they are today. Jim, anything to add? We satisfied with covering that element?
I believe so.
Okay, then the last one is the big one. Unnecessary hardship. In the context of these variants, the court stated the test to mean hardship exists when owing to a special condition of the land, there's no fair and substantial relationship between the general public purpose of the ordinance and the specific application of the ordinance to the property at issue. Now, that part of it right there, just to start the conversation, relative to it, there is, I don't understand why, for the life of me, why auto repair, which is a very common, respected businesses everywhere, why that would be a negative to that particular area, especially considering that it already is in the area.
Plus, by special exception, you could repair RVs there.
That's a good point. I hadn't thought about that. It's true. You could do that.
Sales
Mhm.
and repair of RVs.
But that's true. And keep in mind that at one time, there was a small engine business out front of there. I was there for 4 or 5 years, as I recall. You know, that's gone too.
Yeah, it occurred to me that it's very
Okay.
inconsistent, when it was rezoned, when there was so much use there of the automobiles, and also allowing the special exception, by giving right to put cars there as a parking lot, you'd have a lot less control over whether any oil or anything was leaking from cars into an area, and which is a right, and then by special exception, you could have RV sales and service. And they're much larger vehicles, they're much, I would think, affect the area much more than automobile repair, which is a very common all up and down Route 3.
Okay, thank you for bringing it up. I hadn't considered that aspect of it, but there's like an inconsistency within the ordinance itself.
Absolutely.
And once again, it does appear as though for some reason when the ordinance was created, somebody has something to do, something against auto repair.
Right.
And for the life of me, I can't understand why anybody would do that. What's wrong with auto
Well, you know,
repair?
if you think that's gonna change the area, you know, it makes no sense. I mean, those other businesses are never gonna go away, so,
Mhm.
you know, as long as they carry on in the same business, they'll be there perpetually. What difference does it make if they do the same thing across the street?
You would say something, Bob?
No, I made a comment. That's one of the original drafters of today's zoning ordinance.
So why'd you do that?
Of course, I was running it, mine was running the committee, but another committee member that was involved, but, yeah. I really don't know why that was excluded at this point in time. You know, we got,
You have to explain to
you,
somebody that.
if you have a close look at 674:33, actually allows for deviation from the requirements of the ordinance, such as a limitation on a permitted use or restriction on use, where the intended use is reasonable. So,
You're denying somebody the use of,
yeah,
a reasonable use of their property, which, in this case, this is a reasonable use compared to everything around it. So, yeah, I couldn't, I can't understand. It's not a reasonable use to that area when it's common and typical.
I guess what we're looking at is there a fair and substantial relationship between the public purpose of the ordinance and the specific application of the ordinance?
I can't see the public purpose of it.
I don't either.
And I don't see where it doesn't violate any of the intentions of our ordinance, which I read off before, the lessening the congestion, you know, the things that we have a purpose for this ordinance for. This, doing auto repair does not at all violate any of it.
yeah, that's right. I mean, it's our responsibility to not deviate from the provisions of the ordinance at all, we make sure that it's done properly,
Yeah.
and in good taste. To no harm to neighborhood. So. But certainly the provision is there to use it.
And it can't be all one-sided, any of this, because, you know, if you read anything that the court said, it's got to be fair to both sides.
Okay.
And this is certainly, I think, my opinion, is not fair to the property owner.
I also have something in another long lecture relative to this particular question. And this is relative to the Simplex case, but finally the court recognized again the constitutional rights of landowners require the zoning ordinances must be reasonable, not arbitrary, and rest upon some ground of difference having a fair and substantial relationship to the object of the regulation. And it doesn't seem, there seems to be a significant problem within the ordinance itself.
Exactly. I agree.
Now, this is the first part of the hardship requirement to begin with. The second part of it is that the use for the variance, for which the variance is sought, is reasonable. The proposed use is a reasonable one.
As I've said before, I believe it is reasonable. It's common and typical for the area. It's not going to detract from any of the neighbors.
else has anything to say on that particular issue. I mean, I certainly feel it's a reasonable thing to take place. The auto repair is everywhere and all over the place. Why it should be restricted out of a particular area just doesn't make sense.
The hardship is right here. Only when some characteristic of a particular building in question makes it different from others can unnecessary hardship be claimed. We've already said that the land is, the lay of the land, it's set lower, it's different from everything around it.
And it doesn't really lend itself to
It wouldn't lend
a
itself to any
so-called
of the other.
another retail business.
Exactly.
Having been a small businessman myself at one time,
Yeah.
the actual business itself, to establish a business, is gonna cost money.
Mhm.
Nobody's gonna put any money into that kind of a location unless they buy it and redo the whole location.
Right, you'd have to tear down the building, fill the land,
Or build on the front
or
part.
build on the front.
Yeah.
I mean, there's not enough room on the front part to build the building and have the setbacks. If you look at that lot, it goes down pretty fast right after the front of the building. You know, it goes away. So I do believe they'd have to tear the building down.
You put it
And you
to
can't even
repair.
and the other is, you can't even get another business, and, you know, the one right next door, less than a year, and that's a restaurant. And that didn't, you know, that's not the type of area that
Yeah, the ice cream place next to it
Yeah.
didn't even survive, right?
it's not an area that you're gonna get any retail. And you can't even fill, I mean, look in Belmont, they can't look at the Belmont Mall. I bet they haven't had that place completely filled ever.
And it's,
Jewelry store just closed Saturday, I think.
Did it? Yeah, yeah. I mean,
Been
it's,
there for years.
you know, so this has no chance. And I think that's, you know, unless, that it's, I believe, unfair to the property owner.
I guess, you know, the claim that somebody has made that all kind of businesses would go in there. Now, yeah, they go in there if they wanted to throw their money into an area that really doesn't lend itself to successful businesses.
It's not. And I looked at every other use that's permitted in that area, and I can't see any of them that this this particular piece of property would be able to support.
Yeah, I concur. Well, unless somebody has anything else to say on that part of the hardship criteria, that part would allow him then to have an unnecessary hardship. And he doesn't have to go into the B section of the criteria because he meets the first criteria.
I agree.
See, I had a problem with the first criteria, subparagraph, small, high. That one didn't pass for me. The second one, the double I was okay with that. I found the answer in subparagraph B.
What was yours?
Just what I said earlier, basically what you guys
Well,
were
let's
talking
talk
about.
Yeah, it's the same.
Okay, let me ask you this then.
Yeah.
If the little I is no fair and substantial relationship exists between the general public purposes of the ordinance provision, which in this case is preventing that, and the specific application version, is that to say that there is a substantial relationship?
I was relating that to the physical characteristics of a property that prevented a structure, for example, being placed there. I don't know.
I'm following you.
So, yeah, I think I might have initially been thinking in the wrong direction on that. I mean, that's what I came up with it. For example, like I said to Giorgio, you might have a long, narrow lot, you're trying to put an oversized house on it, or something of that nature. But here again, I may have misinterpreted the actual literal meaning of that. But I didn't dwell on it anyways, I just went on to subparagraph B, basically found the same answer that everyone else did.
Yeah, if you look at that, under the fair and substantial, I have another, from the local government center, and it
Yeah.
says, you know, what are the general public purposes of the ordinance?
Mhm.
Which can include public safety, separation, inconsistent uses, reducing traffic congestion, encouraging development in a particular section of town, mitigation of noise problems. This use doesn't do any of that.
Right. It doesn't.
So there's no.
So really, A is okay.
A is okay,
Subparagraph
because
A and subparagraph B
I
are
think-
both.
I agree. I agree with that.
Mhm. Okay, so you, what you're both agreeing to at this point then is that it really, well, either way you can look at it.
Yes, it passes.
It does establish the fact that there is an unnecessary hardship.
Okay, exactly.
Okay. Ladies?
Mhm.
Goes.
Well, let's see what's next. Is everybody content with whatever they had to say in that? Are there any further discussions at all that anybody wants to get into any one of the 5 criteria? I feel we covered it also. Okay, if there's no further discussions, I feel that just to summarize here, that the board members are very familiar with the building and the site, and they agree it does not really appear there would be many types of business that would want to be in that type of location. Normally, auto repair is a respectable business and to not allow it to exist, especially when that type of business already exists in the immediate area, would be to deny a reasonable use of the property for the owner. And finally, in the mixed-use description of this ordinance itself, it calls for small retail and service uses, and that is what this is.
Exactly.
So that being summarized at this point, I would say a motion would be in order.
How do you make something like this, that our original decision stand?
I'm just about finished with something.
Well,
okay. All right.
We can make a whole new motion at this point in time, because we already suspended the original. So we should make a new motion. And I do have well, I'll get into the conditions after I hear the motion. I did have,
Do you think we have to repeat the conditions all over again, or just refer back to the original?
no, I think we should make a whole, I don't want to be any, I'll make a whole new motion. And we can talk about the conditions. I do have a slight modification that I want to make to one of them.
All right. This is just an initial draft, and I haven't really looked it over. It seems kind of lengthy to me, but let's see what you guys think. I was just kind of messing with this while you were talking. Motion, following a thorough review of the minutes from, no, I shouldn't say thorough
No,
review.
that's it. Let's just stay with the motion itself, preferably not having
Background?
any background with it. Where
Okay.
we can utilize my summary as the reasons for whatever.
Okay. So you don't want to go into the fact that all members were in agreement with the responses to all the criteria? No?
Now, the minutes should show that,
Okay, okay.
and so with the
All
video.
right, so the motion then would start off,
Take
reconsideration.
your time, just take your time, there's no hurry here.
All right, I'm just gonna throw something out, see what you think. The board's reconsideration of ZBA case 16-1 has reinforced our original decision to grant a variance. And that's hacked up, I mean, that's not the way I wrote it, I just gotta.
Can't we just modify that to make a whole new motion out of it? Okay, that either a motion to approve or deny the variance as requested.
You don't need to get the reconsideration in there?
I don't think so, that's what the minutes have.
I mean, if I may speak, I think that, you know, you guys have made it clear that this isn't your typical motion, you know, this wasn't a typical response to a motion for rehearing. You're not doing your typical rehearing, instead you suspended your past decision and really you're revisiting. This, in a way, this isn't a rehearing, this is a.
It's not a rehearing.
Right, so, to me, it seems what Chairman Plessner is saying makes sense, to kind of just, you know, issue another motion as you would at an original hearing, and let that become the new notice of decision, or the new decision. That makes sense to me,
So,
Maybe just,
Do you agree with that?
yeah,
That the word reconsideration doesn't belong in here at all?
no,
No.
no. Just, sorry. This is
because we didn't accept anything.
We rescinded, we suspended the last one in totality,
Yeah.
now we're gonna make a new one, and I think that's the best way and the clearest way to address this. So I would say just a motion to approve or deny with, and then we'll talk about the conditions that were originally there to finish up the motion.
Well, the original motion then, if we repeated it, was to approve case, ZBA case 16-01, granting a variance pursuant to zoning article, Roman numeral 6.1.G3 in parentheses, to allow for motor vehicle repairs and maintenance at 496 Laconia Road with the following conditions.
Okay?
1, a maximum of 6 vehicles shall be present on the exterior premises, excluding employee vehicles. And I think he was okay, should we specify that those should be on the back side of the building? Because that was what we discussed, not out front. Does it not
I
matter?
don't think that's a technicality there.
Okay.
And this is the backside.
2, that the planning board shall be consulted to determine whether site plan review shall be necessary. And 3, this approval shall become null and void if the automotive repair aspect of the business is ever abandoned for a period greater than 12 months.
Okay, that's the one I want to change.
Okay.
Although, just a little bit. After reading some case law, I wanted to change it to the approval shall become null and void. The variance shall become null and void if this automotive repair business should cease operation. That way it applies to this particular business.
Just should cease operation.
Yes.
Okay.
But you wanted to change approval to variance.
Yes, change the word approval to variance.
So the variance will become null.
Oh, so approvals change the variance?
Yes.
Yeah, okay.
Then it
Yeah,
makes,
that makes sense.
Yeah.
Okay. This variance should become null and void. If this automotive repair aspect of the business should cease operation. Yeah. Good change. All right.
Do we need to spell out this automotive repair aspect?
Excuse
Do we
me?
need to spell out this automotive repair aspect referring to Jeremy Perkins' business? Or
Okay.
do we need to get that technical?
That's a good question, because that's the intention of putting the word "this" in.
Yeah?
Okay, what do we,
But could somebody new buy it and continue on with the business?
Yeah.
Yeah, if the
As
business-
long as, so it's
if the
this.
business- yeah,
If
it's
this
still-
business ceases
continue
to
as a
exist.
continuation, yes.
Right, so then
This-
somebody can
okay.
buy the
But-
business, but it would say, I think that's.
But if he decides to pull out
Yeah.
and stop business and go somewhere else, then
Right.
that's the end of the
Right,
variance.
if he doesn't sell the business, it just drops it,
Right.
then it's gone.
Okay, so knowing that,
Wait a minute, where are we at now?
No, you
Change wording?
we didn't
You're
change
good.
it.
you're good.
It's this, we're not gonna add his name to it.
No.
I didn't think so.
Okay, so now, with what we've discussed here, you want to cover the actual motion that you want to make, which hasn't really been made yet?
I thought we just did.
No, we kind of talked all around it. Let's hit it directly.
You wanted me to repeat the whole thing
Once-
again?
Once you make a motion, or if you want, I will make the motion.
Yeah, maybe you better, because I'm confused at this point.
Okay. I make a motion to approve ZBA case 1601, granting a variance pursuant to zoning article 6, period, 1 period, G parenthesis 3, to allow for motor vehicle repairs and maintenance at 496 Laconia Road with the following conditions. Number 1, the maximum 6 vehicles shall be present on the exterior premises, excluding employee vehicles. Number 2, the planning board shall be consulted as to determine whether site plan review will be necessary, shall be necessary. And number 3, this variance shall become null and void if this automotive repair aspect of the business is ever, or should ever cease operation. Did you get that?
Yeah, I wonder if, based on what you just discussed, if you wanted to add, say, if this automotive repair business should cease operation in this location, just to completely cover the ins and outs of what you were saying. But
At this location.
Yeah.
it's probably obvious, but.
Okay, well, I mean, nobody else could ever carry a variance to another location, but
But they could carry the business to it.
Yeah, I know, it's,
we're talking about the variance.
I don't think it's necessary.
I don't think it's necessary.
oh, that's fine, yeah.
It's a good suggestion, but I think we're covered here.
Yeah.
I'll say that.
Oh.
Actually, I'm sorry, let me just continue on that. So let's say the business doesn't cease operation, but it moves to another location. Based on the way you wrote that, the variance still stands. Because the business hasn't ceased operation.
Oh, okay. So
He's
somebody else.
moved to Amsterdam, he's doing a car repair business in Amsterdam, and because of the way
Okay.
this is written, the variance still stands
So
at
just
496.
just add the words "at this location."
Well,
Just put the address.
that's the purpose of the variance.
Yeah.
change.
Okay,
I mean,
limited.
it can run with the land forever as long as the automobile repairs are done there, irregardless of whether it's Jeremy or anyone
Right,
else.
but you guys are trying to clarify conditions of when it would become null and void. So based on what you wrote here, let's say he picks up his business, he doesn't cease operation, he leaves that location, let's say he moves to Londonderry, starts doing a car repair business.
He's gone.
in Londonderry, okay, so he has not ceased operation, he's continuing operation.
But he's not continuing in that location.
Right,
He still
That's
has
all
to
he's
get-
saying, is
he
add
still
that
has to
word, those
go
words.
through the same process in Londonderry.
no, so he's, whatever happens in Londonderry happens. Now, you've got this that says, this variance shall become null and void if this automobile repair business should cease operation. And the person who moves into that building 6 months from now, whoever it is, could say, no, this isn't null and void. That guy never ceased operation.
That's correct.
Yeah.
That's correct. Yeah, that, and you're absolutely right, it doesn't cease. As long as, and that's what we're saying, automotive repair aspect of the business, okay?
Mhm.
As long as that continues, whether it's by Jeremy or another individual that follows him. It's
And
the
if you
variance
really
states,
But,
it
Because I
runs with the
feel that-
land.
yeah,
No, get
but
away.
that's not what Joe's trying to accomplish.
Yeah, but it, okay. Do we even need that? Because in my opinion, that use is not,
It hasn't been discontinued.
and when that use, I think, is appropriate for this area. I think it's the, you know.
Well,
So,
maybe so, but,
right,
we're just talking about whether or not the variance
But-
applies or not.
it doesn't, yeah.
Well, but what we don't want to happen is we don't want the problem that has developed over the years of its ceasing operation, and then 5 years down the road, somebody wants to start something up and say, wait a minute, there's already a variance allowing this to happen, but he might be doing it in a totally different way. Okay?
Oh,
I see what you're saying.
So.
okay, that could make a difference.
Now, if you feel that you want to clarify cease operation in this location, I'm fine with that amendment.
Yeah, why don't you do that?
I think it covers what
Yeah.
Mr. Chairman Pleasant is trying to
Yeah,
accomplish.
I think so, too.
There was another thing that you gotta say.
Oh, okay.
The variance for this location,
So no time frame involved?
no,
No.
no.
Okay, so you're saying in this location, at this location?
So what, do you have it,
Yeah, can you read it back?
Darren?
The last.
Yeah,
third
the-
one,
the final.
yeah, the variance shall become null and void if this automotive repair business should cease operation in this location.
Yeah, that makes sense.
Okay,
And you
I've
seconded
I've
it?
I'll
okay,
second.
you've seconded the new
Yeah.
amended motion. Okay, any further discussion?
No, I
Okay,
think
time for a
everybody
vote.
did a good job tonight.
All in favor?
Aye.
Any opposed? None opposed? So the variance has been granted. And we can move on to other business.
Bring your letter in. Bring your own letter in. Want me to read it?
In that case, I got a piece of correspondence I want to pass around to everybody, and they can acknowledge it with their signature.
Oh, you just go right there.
I'm trying.
Now, keep in mind, if you're not comfortable with it, you don't have to go there.
It's nicely done.
I don't count one way or the other against anything.
Okay. I'd like to read a closing statement regarding tonight. Would that be appropriate?
You wanna deal with this first?
Oh, we have
Yeah,
minutes on that?
let's finish up.
Oh, yeah.
Let's get back to that.
Oh, is everybody reading a copy of that?
Well, it's gotta be one
What
copy.
copy, certainly, yeah.
Just, I don't know, there is the other case on the agenda.
I would remind me that I've got it planned for the last item.
Okay, all right.
Thanks for the reminder.
Yeah, no problem.
Wait to be here. Take care of any go to London.
Oh, really?
Can I make mine?
Nice with
You certainly can. You certainly can.
No.
Just not involved in it.
you. Next time I see you.
It's not good, something perfectly early, but I understand.
Okay, thank you.
I'm pretty sure it's on. And then, oops.
Oh. London. Oh, roof. Right.
Yeah, that's fine.
Did you get this, Marie?
You should choose to go right around, which is fine. I figured either George or Marina would want to do that.
She would want something.
Sign mine, just, I didn't have to sign yours.
Yours must be good.
Okay, we'll make copies of this when we're done. I guess Mr. Brown would like to read something into the record in the minutes. You have the floor.
Thank you.
This will become part of the minutes also.
Okay.
Okay.
I don't know if I can write fast enough between the tape and the video. I
Bill,
will make sure.
Speak clearly.
At the center of this evening's reconsideration of ZBA case 16-01 was a memorandum drafted by Selectman Dawson accusing the ZBA of disregarding the zoning ordinance and failing to apply the appropriate variance criteria in reaching our decision to ultimately grant a variance to Mr. Jeremy Perkins following extensive deliberation. Where Selectman Dawson could have simply drafted a letter to this board stating that we might have erred and why, asking for reconsideration or a rehearing, she instead loaded her memo with false accusations, an indirect lecture to the board, and capped it off with the threat of micromanaging our work in the future. Her unprofessional approach to a simple appeal process is indicative of deep-rooted sentiments and a lack of respect for experienced ZBA members who work diligently to uphold the standards of our zoning ordinance. I'm sure that I speak on behalf of my fellow colleagues when I say that lashing out in this manner is not only demoralizing to this board, but beneath the dignity of a selectman and a gross display of poor demeanor. Thank you.
Okay, there you have it. That being said, I'm going to read the following letter into the minutes. It is a well-known fact that in recent years it has become increasingly difficult to find good and credible volunteers to serve on municipal boards and committees. Volunteers whose only goal is to serve the public and to honor local regulations in good faith. For years, this board has struggled to recruit and retain a full board of dedicated members as a result of the above phenomenon. As a quasi-judicial board, it is incumbent upon our members to follow certain lawful procedures to research each case law and to use sound judgment based on evidence and fact when rendering a decision. This is especially critical when adjudicating an appeal for variance from current zoning regulations. Recently, the Board of Selectmen challenged our decision in ZBA case 1601, wherein relief was granted in the form of a variance by applying the criteria specified in RSA 674-33 to allow the owner reasonable use of his property. This apparently infuriated Selectman Dawson, who chose not to discuss her personal sentiments publicly at the Board of Selectmen meeting on June 23rd, but instead distribute a scathing memorandum to the other board members. No discussion of the memo's content ensued for obvious reasons. Accusatory and threatening in nature, the memo contained little or no new evidence to substantiate a rehearing appeal to the ZBA. Puzzled and unable to draft a letter of appeal on their own, the Board of Selectmen opted to hire legal counsel, which had the effect of elevating the process beyond a friendly board-to-board exchange. It saddened us that despite our long-standing acquaintances with the Board of Selectmen members and our appreciation for the responsibilities that they bear, not one of them rose to verify the accusation and threats by Ms. Dawson. That being said, it seems like the best way to resolve this matter is for you to consider this our formal notice of resignation by the below-listed members of the ZBA, effective on September 1st, 2016. And that date being selected so that we can meet once more to approve the minutes of this meeting, after which it'll be up to the Board of Selectmen to create a new board, if they can. So, after spending $1,000 on attorneys and wasting a lot of our time, this is not in the letter. But what do we have? We have the same decision, and a lot of money spent for no real reason. But now they also don't have a zoning board.
Very sad.
Okay, so that being said, I think that concludes everything with the exception of the second case that was supposedly going to be in place tonight. The individual has asked for a continuation, but given the circumstances now that we can't give them a time certain when there will be another board, we can't very well give him a continuation. So I would say what I need is a motion to not continue with the recommendation of, inasmuch as it'll be the town's fault for not having a board in place, it might take a while, so the town should, if anything, pick up his costs to resubmit, because we can't continue it.
So I assume that this gentleman wouldn't be ready prior to the 1st of September, is that correct? I mean, this isn't something we could deal with at our next meeting.
No, I doubt that very much.
Okay,
I don't even want to go there.
okay.
It's, you know, he's got to work out some things with his property
Okay.
right now, because he could not have come before us with his request that we could actually honor in any way, because it's unresolved. It's just what he's allowed to have there already. If I'm going through the paperwork, it gives the impression it's whether he's approved of 5 and questionably 8.
Yeah.
He's already got 9, asking for 10. That's going to have to be resolved before anything comes before this board. So I would.
That's not a short term.
I would make a motion that we do not continue this case, and with the suggestion that if there's any additional fees, it'll be the town's fault for not being able to continue it, and the town should pick up the cost. Of course, that's not my decision to make, but I'm just, if that's a suggestion,
Yeah, so recommend that there be
recommend.
no cost to
Yes.
this for
So that being the motion, I need a second.
Second?
We have a second. Any further discussion?
Are we relaying that we're all resigning?
I'm sorry?
Well, because it just said this number is only.
Right, normally if you continue, you have to continue to a date certain, date and time certain, and we can't do that.
Right.
Because we focus on, well, purpose of resigning at the moment.
Is the effect that all 5 members have resigned? Is it-
Right.
Okay,
Yes.
Well,
One's gonna be on
for,
our separate.
okay.
for a signature, the other one wants to write their own letter of
Okay.
resignation.
Okay.
So
Okay,
you have to take a vote on that?
yes, we do need to take a vote. We have a second with Bob, all in favor?
Aye.
Aye. Opposed? No. Okay, well, the only last thing I'd say is that I'd like to thank all of you for being part of the board. And I thought we've had a good time, and it dismays me to have to deal with this type of an issue, but I think all of us really kind of took a shot for the knees to see it approached this way.
Life's too short to
Exactly.
get muddled up in this stuff. It's too much.
Absolutely.
The time
I
that I
didn't join to be in politics.
The time that Bob and I have wasted, and George has wasted, and
Just get
you've
that
wasted,
done.
and now on the books, just doing the same thing we did the first time, is all for naught.
All for
Now,
naught.
that doesn't mean that that this can't be, this case in question can't be challenged to the Superior Court. But then that'll be up to the judge to remand it back to the board in existence, or to make his own decision.
Yeah.
I don't know where that will go, and at this point in time, whereas September 1st, it won't matter to me. So that being said, I thank all of you.
I'd like to thank Dari for his excellent
Yes, thank
support.
you.
Yes,
Yep.
thank you, Dari.
Sorry
They're real
to
close
dump
to
this in
working
your
with you.
lap.
Oh, well, they're not gonna let me hear the case. Could be a few months of me, Tuesdays, third Tuesdays off for me.
Well, there you go.
No, thank you, it's been a pleasure working with you guys, really learned a lot, thank you.
Hate to leave this way, but
I hope they can find someone that can run the board the way they want. That's actually, I should say, the way Ms. Dawson wants.
mhm.
And that,
Yeah, somebody on that board needs a tune-up, that's for sure.
we can still meet every third Tuesday at 99s or something if you want.
Pizza and beer?
And we can do it that way. But,
Yeah, I think everybody's done a great job. This has been a good board.
yeah, we always kind of look forward to the gathering, if you will, and dealing with the problems that, came before the board.
Yeah, it was challenging,
During
some of them.
sometimes they get a little bit involved, like the one that took 5 meetings a while back to
Yeah.
finally deny, those variances that we don't ever deny according to Ms. Dawson.
But we did give the applicant every opportunity to try and resolve it.
Yeah, oh yeah.
He could not say we didn't, that's for sure. No one can say we didn't. You weren't a member of I think it was 4 months, actually. Do we have to do
Yeah,
that?
are we done?
We need a
So moved.
a motion to,
So moved.
7:17.
To adjourn.
So I
Adjourn.
will,
to adjourn, I thought we
Yeah.
make a motion.
Yeah.
No, to adjourn.
No,
To
all in
adjourn.
favor?
Okay, motion in favor to adjourn, seconded,
By me?
all in favor?
Aye.
Aye,
So I will,
so there we have it. And I'd like to get Derry to make a copy of this.
I'm not, I can't.
We would.
Oh, well,
No,
okay.
it's
Till Friday,
No, that's-
Yeah.
first time this summer.
Just plain and simple.
And I
Oh,
told
okay,
Titus, I
okay,
said,
that's fine.
"You've been watching
And make a
Titus."
copy of each,
Okay,
and then
Yes.
you can take this master
Oh, he
copy,
says beautiful now. I
And,
said, I don't think it's gonna rain.
deliver that to Gail.
Well, I
and
guess I better
Okay,
go along
yeah.
and see, make sure you're safe.
Did,
We're gonna.
I thought I saw George hand one.
Sure enough.
Oh, he's,
He comes and I
He
have.
was-
I have my own, but I
Okay.
decided to go with
okay,
this.
All
She
right.
gets to my house, she's got the convertible top here, 3 of them,
No.
sunglasses, playing, you know, they're all roll, big smiles on their face. I pull out and follow me. As soon as we got on 104, aim towards
You can't
Bristol,
question that.
could see black coming up over the trees. I said to my wife,
Just think all
"This
this
is it."
paperwork and stuff
I
that
got
we
into
do,
Bristol.
file
Almost out of
cabinets on home with
Bristol,
this crap.
first spots in my
On
own.
fire.
So I said to Eddie,
And he will-
watch his turn.
Oh, sorry.
He said,